This is for NTI Day. I believe it's 9. It'll be Tuesday, March 24th. When we're talking about the other 14th Amendment cases. So on Monday's NTI Day, we focused on the 14th Amendment cases that deal with the right to privacy. We're going to focus on some of the other 14th Amendment cases today. So I've kind of blocked them off into two ranges. The first one is the liberty cases. So these are the cases that give people rights or don't give people rights. First case is Washington versus Glucksberg. This is the right to die case. Dr. Harold Glucksberg and 3 terminally ill patients sued the state of Washington over their ban on physician-assisted suicide. They stated that this was a liberty issue and this is protected under the Due Process Clause of the 14th Amendment because it gave you the right to choose, basically in this instance, death over life. And so they said, by banning this, you're prohibiting me this liberty that's protected by the 14th Amendment and therefore should not be held. The court obviously did not hold that. They said, look, the purpose of the Due Process Clause was to protect certain rights, such as, your right to life, your right to be treated equally, things like that. This was not the intent of the 14th Amendment. And really saying that you have the right to die would really be offensive to our values and our beliefs in the United States. So we held that the 14th Amendment does not protect your right to die. Now, it doesn't mean that a state cannot enact right to die policies. I know several states, I think Washington has reversed, and now they do allow physician-assisted suicide. So that doesn't state that you can't have this, but what it does state is that the federal Constitution doesn't basically guarantee you a right to die, is basically what this case said. Obergefell versus Hodges. So this is a case y'all were alive for, so I always think it's, fun to talk about cases that you might have remembered when this came out. So some same-sex couples challenged the state's bans on same-sex marriage bans. Like in Kentucky, we had a same-sex marriage ban. And so several couples from states across the United States sued, stating that these same-sex marriage bans violate the 14th Amendment, the Equal Protection Clause. And in a very divided court, in a 5-4 decision, they basically said that one of the liberties that's protected under the 14th Amendment is the right to marry, and that right to marry applies equally to same-sex couples as it does to opposite-sex couples. Anthony Kennedy was the swing vote on it. He voted with the 4 more liberal justices. The 4 more conservative justices in the court said that the Constitution says nothing about the right to marry. This is a created right. There's nothing in the Constitution that says, you are guaranteed a right to marry whoever you want, whoever you said it did. And they hinted that this is going to create more problems down the road. What they mean by that is there's going to be more liberty cases that come to us, like, the Baker case, right? You have the Christian Baker and the same-sex couple. Now that same-sex marriage has been nationalized across all 50 states, the court now is going to be put in this political arena of having to decide, who wins in this instance. Is it the same-sex couple or is it, the Baker? And so this decision, honestly, not only was it big, obviously, because it made same-sex marriage legal, but it also brought more questions to the forefront, kind of like the Baker case that we talked about. Civil rights cases. So these are cases where the government is protecting your rights. Okay, these are not protections against the government. These are being protections afforded by the government. So the Dred Scott case, this is pre-14th Amendment. Dred Scott and his owner moved to a free state. After the owner died, Dred Scott claimed, hey, look, my owner's dead. I live in a free state. There's no slavery here. Therefore, I should be a free man. And so he tried to get his case heard by the Supreme Court. The Supreme Court said, sorry, we're not going to accept your petition because you are not a person. You are property. And property doesn't have the right to, petition the court to hear cases. And basically it said, in fact, the right to own property extends not only in the southern states, but extends to all states. So really, it said that slavery was essentially legal everywhere in the United States because you had the right to own property wherever. So therefore, basically, you could own slaves wherever you wanted. This is widely regarded as the worst decision in Supreme Court history, without a doubt. And basically, it sets the basis for a need to have a 14th Amendment, which the 14th Amendment, would be used to grant equal protection under the law and allow to grant individuals certain rights and liberties that everyone, not just a certain group of people, should have the right to. In this case, you can kind of point to as a need for the 14th Amendment. Plessy versus Ferguson, 1896. Homer Plessy, he was an African-American man living in Louisiana, I believe. And there was a law that said rail cars had to be separated for colored individuals and white individuals. So Plessy wanted to sit in a white people car, and so he was sitting in the car. They said, "You need to move." He said no. They arrested him, and he basically said this separate car act was a violation of the 14th Amendment. And in a 7-1 decision, the court said no. And they established the very infamous separate but equal doctrine, which basically said segregation was not unconstitutional. I mean, separating people, I guess on the basis of their skin, in essence, is not unconstitutional if there is no meaningful differences between the two. Well, obviously, you could say, okay, yeah, in a perfect world, if people could just be segregated, into different races, and we could all just treat everything equally, then you could maybe say that could work out. But obviously, when you create separate cars for people on different races, there's a reason why you're doing that. You're not doing that, just because. You're doing that because this group of people doesn't want to sit with that group of people. So therefore, there's obviously several issues in this case. But the thing about it, this case is going to stand for about 50 years. And so this kind of becomes the basis that as long as you could prove that things were separate but equal, then segregation was okay. But also the other problem was it really wasn't separate but equal. You could also look at schools for black children in the South and schools for white children in the South and clearly see that it was not separate and equal. Korematsu versus the United States. Fred Korematsu was an American citizen of Japanese ancestry who refused to relocate under FDR's executive order. He stated that the law violated his due process and equal protection rights found in the 14th Amendment. And the court said no. And they said the president, as commander-in-chief, has the right to mobilize the military to take Japanese Americans and relocate them to internment camps because basically the court said we can't discern between which Japanese Americans are loyal members to the United States and which Japanese Americans are disloyal members to the United States. And the dissenting opinion, this is a 6-3 decision, this dissenting opinion is like, hold on there a second. It's pretty clear, right, that you are violating their due process rights, right? These people, they committed no crime. The only reason you're gathering them up is because they are of Japanese ancestry. So you're not giving them any chance to prove their loyalty. And second off, this is obviously violate a gross, racism, violation of the Equal Protection Clause. You're not treating them equally to all others. In fact, think about it. It's not like German Americans or Italian Americans were being interned during this time. It's just Japanese Americans. And so this is probably, you could say that this is also one of the worst decisions in Supreme Court history. And it was just overturned a couple years ago officially, even though the United States government, said they were sorry, paid reparations to survivors. Officially, in the Trump versus Hawaii case, the court officially said Korematsu versus United States has no law. Then lastly, Brown versus Board of Education. This is one of our essential cases for AP government. Oliver Brown and several other parents sued the Topeka, Kansas School Board, demanding that their children be allowed to attend previously all-white schools. And the school board said, no, you have to go to the segregated all-black schools. And so they eventually brought suit through the NAACP to the Supreme Court that basically says segregation violates the Equal Protection Clause of the 14th Amendment. And it was a unanimous decision, and the court said this is really important that we explain to the average everyday person why segregation is so wrong. So instead of having this massive opinion that uses legal phrases that the average individual would not be able to read, it was basically like a one-page decision that was put in the papers because they wanted the people to be able to read this and be like, oh, I understand what the court was doing here. I understand the reason for this and the idea that people could see why segregation was wrong. And basically the reason why they said is because, first off, there's no way to create separate but equal facilities for people based off, racial features. Okay, it's basically impossible to say, okay, we're gonna have one school for this individual and one school for this individual who are separated by race, and it's going to be the same except they're just different schools. It's virtually impossible to do that. Secondly, the court also said that segregating children on the basis of their skin color for education creates this idea of an inferiority complex, that the kids that don't go to the all-white school, they're not as good as the white kids because that's why they have to go to a separate school. And so that obviously is a gross violation of the 14th Amendment. And so this decision overturns Plessy versus Ferguson, basically says you cannot have separate but equal. Okay, it's basically impossible to have two separate schools that are going to be completely equal. I mean, if you look at Madison Central and Madison Southern, which are not segregated based off of race or differentiated by geography, you could clearly say our school and their school are not the same, right? You can try as much as you can to make them the same, but they're just not going to be the same. And so that is what the court ruled, overturning Plessy versus Ferguson, and basically established that segregation had no constitutionality to it whatsoever. All right, so that brings us to the end of our 14th Amendment cases. We still got a couple other things to look at with civil rights and things like that. The school board told us that we don't have to give out assignments every day. So to kind of break up some of our work and things like that, on some of these days, I'm just going to have you listen to my lectures. I'm not going to make you turn in anything like this. And then at the end, you just submit, use the honesty policy and click the yes, I listened to the lecture button on the Google form. If you got any questions, let me know. Hope everyone's doing great, and we'll see you soon.